This ruling protects presidents and traps one man. That's the contradiction at the center of what just happened. After 248 years, the Supreme Court finally ruled on presidential immunity from criminal prosecution. On its face, it sounds like protection. Stronger than before, clearer than before. But if you're paying attention, it also quietly redraws the danger line, and it redraws it right under Donald Trump. Here's the fact. Chief Justice John Roberts wrote the opinion. The court ruled that a president has absolute immunity for actions within core constitutional authority, presumptive immunity for official acts, and no immunity at all for unofficial acts. The vote was 6-3. Justices Sotomayor, Kagan, and Jackson dissented. That's not speculation. That's the holding. But here's where the story flips. For the first time, the court didn't just talk about power. It handed lower court judges the authority to decide what counts as official and what doesn't. And once something is labeled unofficial, the shield vanishes completely. If you think this only matters to lawyers or politicians, it doesn't. This ruling changes how accountability works after a presidency ends. It decides whether cases stall forever or move straight into a courtroom the moment power runs out. Notice what the court did not do. It did not say a president is immune for everything. It did not say campaigns count as governing, and it did not say criminal cases disappear with the office. So while this ruling sounds like safety, it may actually be a funnel. And funnels only move one direction. The real question now isn't whether the rules exist. It's who they point at and how fast they close in. What makes this ruling even more dangerous is what it leaves unfinished. The court answered the big question, immunity exists. But it refused to answer the most important one completely. How do you tell the difference between an official act and an unofficial act? That question wasn't resolved at the top. It was kicked downward. Here's what we know for sure from the record. The Supreme Court said a president has absolute immunity for actions within core constitutional authority. It also said there is at least presumptive immunity for official acts. And it said there is zero immunity for unofficial acts. That sounds clean, but it isn't. Because buried inside that structure is a handoff. Lower courts now have to go line by line, action by action, and decide what category each act falls into. As one analyst said on air, this is the part that changes everything. Not because of what the court protected, but because of what it exposed. At the same time, a lower court, the D.C. Circuit Court of Appeals, issued a separate ruling that hits Trump's legal defenses hard. That court said a president cannot pardon himself. It said immunity is much narrower than Trump argued, and it said crimes serious enough to be impeachable are not protected by immunity at all. Notice the pattern forming. One court defines the ceiling, another starts closing the exits. Campaign-related acts, personal conduct, post-election pressure, those are repeatedly described as outside official duties. And once something is outside, there is no shield left. This is no longer about whether charges are allowed. It's about classification. And classification decides survival. Because once acts are labeled unofficial, the next step isn't theory, it's trial. And that's where the pressure really starts to build. The claim at the center of this moment is simple, and it's uncomfortable. The legal ground under Trump didn't stabilize after this ruling. It narrowed. And the proof is already on the record. Here's the concrete detail that matters. The D.C. Circuit Court didn't just reject the idea of a self-pardon. It spelled out why. A pardon, the court said, is an act of mercy from one person to another. You cannot grant mercy to yourself. That door is closed. Not debated, closed. And then came the second hit. The same court made clear that immunity only covers a very small range of actions. Most of what Trump is accused of doing, according to the charges themselves, was not governing. It was personal or political or campaign-related, and those categories matter now more than ever. Because here's the implication. If an act was done to help a campaign pressure an election or retain power as a candidate, it doesn't get filtered through presidential immunity at all. It gets treated like any other alleged crime. Ordinary rules, ordinary courts, ordinary juries. Now notice what's missing from Trump's remaining defenses. There is no broad immunity blanket. There is no self-pardon escape. And there is no claim that impeachable conduct is protected. In fact, the court said the opposite. If a crime is serious enough to justify impeachment, it cannot hide behind immunity later. That flips the entire strategy. For years, the fight was about rules. Can they charge him? Can they proceed? Can they even try? That fight is fading. What's replacing it is much more dangerous. Because once the argument shifts from, are these charges allowed, to, did this actually happen? Everything depends on facts. And facts don't bend the way procedural defenses do. And that's when the timeline starts to compress. Once the defenses start collapsing, things don't slow down, they stack. And that's exactly what's happening here. Look at how fast the pressure builds when you line up the developments. In New York, Trump has already been convicted on 34 counts. That's not a theory. That verdict exists. In the federal election case, there are 4 counts that together carry the possibility of decades in prison. In the classified documents case, prosecutors filed roughly 40 counts, including charges with maximum penalties of 10 to 20 years each. And it doesn't stop there. There's the Georgia case involving racketeering charges. There are ongoing investigations tied to taxes and fraud. Each case alone is serious. Together, they create something else entirely: momentum. Now, here's the detail that changes how this feels. Trump is 78 years old. Even a moderate sentence by federal standards, 10, 15, 20 years, is no longer abstract. It's arithmetic. A 20-year sentence at this age isn't punishment, it's an ending. Analysts have started saying this part quietly, but it's unavoidable. When you stack long sentences across multiple cases, even if some run concurrently, the realistic outcome isn't 100 years on paper. It's whether someone ever leaves custody alive. And notice how little control he has over that stack once trials begin. Prosecutors don't need immunity debates anymore. They need juries. They need timelines. They need evidence. And much of that evidence is already documented. Documents found at a home, recordings, testimony from staff. This is what loss of control looks like in real time. Not one dramatic collapse, a sequence, a conveyor belt that keeps moving whether you fight it or not. So the question isn't whether pressure increases, it already is. The real question is what happens if this keeps accelerating? And there's nothing left to slow it down. Here's where the story stops feeling linear and starts feeling unstable, because once the immunity question cracks, everything else speeds up at the same time. First, the Supreme Court ruling forces lower courts into fact-finding mode. Judges now have to go charge by charge and decide what's official and what's private. That sounds slow, but it isn't a pause. It's a sorting phase. Once those lines are drawn, cases don't stall, they snap forward. Second, prosecutors now have clarity. They know exactly where to aim, not at gray areas of presidential authority, but at actions tied to campaigns, personal decisions, and post-election conduct. Those areas come with zero protection, no buffer, no delay. Third, timing starts working against Trump instead of for him. A presidency eventually ends. When it does, the status that slows everything down disappears instantly. What remains are active cases, preserved evidence, and prosecutors who already have permission to proceed. This is what compression looks like. Multiple courts, multiple cases, multiple timelines collapsing into one window. There's no single switch to flip and make it stop. And here's the uncomfortable question hanging over all of it. What happens if the conveyor belt doesn't pause and the next stop is unavoidable? At this point, it stops being about courtrooms and starts showing up in real life. Not for politicians, for regular people watching how power actually ends. If you're paying attention, this ruling sends a signal far beyond one man. It tells every future president and every voter that leaving office no longer means leaving consequences behind. That matters because the presidency isn't theoretical. It affects markets, stability, protests, trust, and how aggressively leaders act when they think the clock is running out. For voters, this turns elections into something heavier. The stakes aren't just policy anymore, they're existential. One outcome leads back to executive power. The other leads straight into courtrooms. That kind of pressure doesn't stay contained. It spills into campaigns, rhetoric, and public tension. For ordinary people, this is where the uncertainty creeps in. Will trials disrupt elections? Will political fights turn more aggressive because the personal cost is now prison, not reputation? When leaders feel cornered, history shows they don't calm down, they escalate. And if this feels familiar, if it feels like institutions straining while everyday life keeps moving, you're not imagining it. This is what it looks like when accountability finally catches up to power and no one knows how clean the landing will be. If this tension feels real to you, say so in the comments, because the system just changed and everyone is standing inside the consequences. What makes this moment different from past scandals isn't outrage, it's mechanics. This isn't driven by emotion or politics alone. It's driven by incentives that finally lined up. For decades, the system quietly rewarded delay. If you were powerful enough, you could stall, deflect, appeal, pardon, or run out the clock. Time was leverage. The office was leverage. The spectacle itself became leverage. And the longer something dragged on, the safer you became. This ruling disrupts that model, not loudly, structurally. By separating official acts from personal ones, the court shifted power away from personalities and toward process. Judges decide classifications, prosecutors follow evidence, juries decide facts. No single actor controls the outcome anymore. That's the unsettling part. The system doesn't need consensus or courage from one institution. It just needs momentum. And momentum is harder to stop than outrage. Here's the insight most coverage misses. This isn't about punishing one president. It's about removing the incentive to use power as a shield for personal risk. Once that incentive disappears, behavior changes, sometimes fast, sometimes violently, sometimes desperately. And systems don't announce when they've crossed a threshold. You only realize it after the options narrow and the exits disappear. So when people ask why this feels different, that's the answer. The rules didn't just change, the leverage did. From here, the path forward splits, but neither direction is calm. One possibility is procedural drag. Courts take time to classify acts. Defense teams fight over definitions. Hearings stretch on. On the surface, it looks like delay, but underneath, the cases don't disappear. Evidence stays locked in. Charges stay alive. And once the classification fights end, everything that survives moves forward at once. The other path is acceleration. If judges quickly label key actions as unofficial, trials can start stacking faster than anyone expected. Prosecutors already know where immunity doesn't apply. They focus there. Juries get seated. Verdicts start arriving. And once the first conviction lands, the pressure on every remaining case multiplies. What makes this moment unstable is uncertainty. No one knows which path dominates or when it flips from one to the other. But the direction of travel is clear. The presidency no longer pauses the legal clock. It only delays it. And here's the detail that keeps this from drifting. Trump's age. Every month matters. Every delay cuts both ways. What used to be a waiting game now carries its own risk. So the next move is already forming, not in speeches or headlines, but in court schedules, motions, and quiet rulings that don't trend until they suddenly do. And once that next move becomes visible, the story won't slow down. It will rush. Here's the insight that holds all of this together. The ruling didn't decide Trump's guilt or innocence. It decided something more permanent. It decided that power now expires cleanly and consequences don't. For decades, the presidency functioned like a buffer, a space where time blurred accountability. This decision slices that buffer in half. Official power is protected. Personal action is exposed. And the moment the office ends, the system restarts exactly where it left off. That's the reframe. This isn't a story about immunity. It's a story about what happens when immunity runs out. From here on, every move matters more. Every classification matters more. Every verdict carries weight, not just for one man, but for the shape of the presidency itself. Because once the line is drawn this clearly, future leaders won't be judged by intentions or titles, but by categories and facts. And that raises the final question. If this is the end of one era of power, what does the next one look like? More cautious, more aggressive, or more desperate? That answer isn't written yet, but the machinery is already turning. If you want to understand where this goes next, before it breaks into headlines, follow and subscribe, because the most important part of this story won't happen on camera. It will happen quietly. And by the time everyone notices, it will already be irreversible.